Someone make it make sense.
Probably a couple.
Hello, everybody, and welcome to our next live stream or our current live stream. Welcome back if you were here last night, this morning, earlier. Lots going on, lots of live streaming going on these days. Yes, indeed. Oh, Twiz. Shout out to Iowa. Shout out to Twiz. I did see, by the way, there's some new Idaho docs, but nothing interesting there. It's mostly just, well, all entirely actually, motions to seal exhibits and whatnot. But I'll keep an eye out, of course, if there is anything else new. I went ahead and scheduled a live stream tonight to continue on with the death penalty motions. But of course, if there's other things, then we will prioritize that potentially. So are you not able to see it yet, Twiz? Because I can pull it up and show you if you want, but it's nothing good. Do I ever sleep? Rarely is the answer. What a cute cat. I forget that one's name, but that's very, very cute. Oh, interesting. I can pull it up and show you though, just for your ease of mind, peace of mind. That's the word I'm looking for. Hang on, give me a sec here. Okay, hold on. Puff Puff, of course, how could I forget? It's Puff Puff the cat. Woo! That's funny, pass. Meg, and you know what? We can use our commands now. Yay! Woo! Okay, so here's what we got. So I'll just sort of read the titles here. So we've got Defendant's third supplemental response to discovery, stipulated motion to seal Exhibit C to the response to discovery, Defendant's third supplemental response to request for discovery for expert witnesses. Did they make a motion to seal? Yep, and there's the motion to seal the exhibits. So let me see if there is anything if there's anything in this at all, because oftentimes it's like just they're filing it. Oh, okay. So, okay, kind of noteworthy, I guess. So anyway, so now we have, well, okay, again, we will go over anything that has any actual information in it tonight as well. But there you go. So it's that list there. And then the only other thing that has a little bit interesting, we have this filing for the motion to eliminate with the text messages. And we have a declaration-y thing here. So that is the other somewhat, at least there's something there, right? And what I mean is, like, for example, you get stuff like this where it's like that. We're going to file, we're submitting this. Like, so you see what I mean? That's why I'm not going to read this. Like, it's just, So the ones that have a little bit of information is like the expert witnesses there, and then the declaration, and then everything else is just sealing shit, basically. Sealing defendant state. So they've got the proposed jury questionnaire. All that's going to be sealed. So yeah, that's all that's new here. So, but there you go. There you go. I love the weather command, How old are your kids again, Meg? PG should be fine, I think. Aren't they like 11-ish? Unless PG has changed. I mean, but I like being a kid growing up, I feel like PG was what most movies were that we watched. 7, okay. I feel like we were watching PG movies. I mean, heck, I think I saw my first R movie by the time I was 7. The Birdcage, love it. Still one of my favorite movies. Right. That's what I'm wondering. I haven't seen a new movie in so fucking long. I have no clue. So let me just unshare, reshare. Oh, that's right. Taxes are coming up. I just got a notification thing. So they don't play Minecraft. Is that a question or a statement? Twiz, let me know if you want to pop on and read anything for Twiz Reads. One day we're going to have our Twiz Reads segment. It'll be a special day. Okay, so here's what we've got for Karen Reed, new. First up, we have the intervenor / alleged witness Aidan Kearney's motion to be exempted from sequestration order. Very, very, very Nate Eaton-y, isn't it? With like Nate Eaton and Lori Vallow. So now comes Aidan Kearney and requests that they exempt him from the sequestration. So he states the following: he's been named as a prosecution witness in the above titled action. As detailed below, the Commonwealth has represented that it may, in scare quotes, call him as a rebuttal witness to establish Karen Reed's purported consciousness of guilt. Mr. Kearney is an independent credentialed journalist who's been issued a press pass through the media office of the Supreme Judicial Court. Journalism is his full-time job and his primary source of income. Since early 2023, good morning, Candace. Mr. Kearney's reporting has almost exclusively focused on the Reed case. His coverage of the Reed case includes publishing articles, live tweeting important case developments as they occur, and hosting an online stream in which he discusses and analyzes issues related to the Reed case. His stream often attracts tens of thousands of viewers. Does it really? I didn't know that he had that many people who watch Mr. Kearney for case news, updates, and analysis. The Karen Reed case is a high-profile criminal case, which for more than 2 years has been the subject of extensive local and national media attention. The case is a matter of great public concern, in a substantial part due to Mr. Kearney's reporting on the matter, which started in 2023, and his belief that Ms. Reed has been framed as part of a corrupt and or incompetent investigation by law enforcement, which has included the DA's office, Massachusetts State Police, and collusion with assorted civilian witnesses. I love the assorted part. Assorted civilian witnesses. Mr. Kearney's reporting played a prominent role in the creation of the Free Karen Reed movement, a nationwide and worldwide group of Karen Reed supporters that has grown so large and is so vocal in their support of Ms. Reed's innocence that the court, balancing the First Amendment right of Ms. Reed's supporters to express their opinion, or maybe they meant to say own opinion. Anyway, express their opinion. Oh God, the typos though. Their opinion on the case, I'm fixing it, with Ms. Reed's right to a fair trial created a buffer zone for their free expression prior to the first trial. Due to the immense public interest in this trial, which has substantially increased since the first trial, and the court's concern that jurors not be impacted by Free Karen Reed supporters expressing their First Amendment rights. Well, I will say it wasn't just that. It was both sides, right? It wasn't just because of that. Like, he's not quite, he's kind of misstating in a way. Well, by leaving out the other part, right? It was for anybody, not just people supporting Karen Reed. But anyway, the court has expanded the buffer zone for the second trial. Put simply, the public interest in this case is immense, and it is critical that the credentialed journalists be provided the opportunity to cover and report on the trial. Twiz has been a good mod lately, hasn't he? He's been showing up. I'm just giving you a hard time. Oh, really? Wow. 80,000 people. Wow. 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 Swords are cool. I do agree with that. I like swords. I like a good sword. You know what I mean? As long as it's, sorry. I can literally just quote from Murdoch with the dowel rod with the quail pen. So as long as it's hard enough and straight enough and long enough and the angle's correct. Here, Meg, here. No, just kidding. Yeah, we don't have a portal. I mean, we got the Lori, we got Chad. Are you thinking, do you have something in mind, Twiz, for a portal command? And are you wanting to portal? So, okay. So credential journalists to be provided the opportunity to cover and report on the trial. All right. And what appears to be the latest move For what? Lori and Chad? You can also find the commands here, Twiz. Okay. In what appears to be the latest move, as part of their ongoing plan to silence Mr. Kearney by suppressing his critical coverage of this case, the Commonwealth seeks to exploit the sequestration order by naming him as a potential prosecution witness, which would subject him to the routine general sequestration order entered in this case. Lead to his exclusion from the courtroom and prevent him from reporting on the case. In essence, the mere act of naming Mr. Kearney as a potential witness would enable the Commonwealth to silence a journalist who is an influential supporter of Karen Reed and a leading critic and foe of the prosecution. Ooh, haven't heard that word in a long time. The Commonwealth's desire to entirely gag and sequester Mr. Kearney such that he could not even observe the proceedings or discuss them in any manner will harm the public's right to information on an important matter of public concern, since many people rely on his reporting for updates of the case. If Mr. Kearney were subject to the sequestration order on the mere possibility that he might be a prosecution rebuttal witness on the relatively minor issue discussed below, which may not even be admissible against Miss Reed, it will literally prevent Mr. Kearney from performing his chosen profession, cause him great economic harm, and unduly restrain his First Amendment right to provide the public with information on a matter of great public concern. There is a danger that excluding Mr. Kearney from the courtroom and denying him the opportunity to cover this case will be cited as precedents by unscrupulous prosecutors who in future cases place any vocal critic with a public platform on their witness list in order to silence the criticism of the government. To the extent that the court has any concerns with the impact or content of Mr. Kearney's First Amendment right to report on this case during trial, the court's repeated admonition to jurors about their obligation to avoid any media coverage, in this case, including online media, will assuage any concern that Mr. Kearney's right to report on the trial may improperly influence the jury. Indeed, whether Mr. Kearney is able to report on this case or not should not impact the court's well-founded concern that the jury not be exposed to any outside media influence, irrespective of whether that content tends to favor Miss Reed or the Commonwealth. In considering the Commonwealth's motive for placing Mr. Kearney on their witness list, thereby subjecting him to the sequestration order, the court should take note that this is not the first time the Commonwealth lead counsel Brennan appears to have exploited a witness list by including journalists critical to his position on it for the purpose of suppressing their ability to report on the case rather than a good faith reason to examine the journalist or purported witness. In USV Bolger, the defense team, which included Mr. Brennan, sought to exclude 3 journalists whose reporting was understandably critical of Whitey Bolger, a notorious and treacherous gangster and murderer, by naming them as potential witnesses against Bolger. Interesting. I did not know that. The court denied the defense's effort to exclude. Now, I mean, that was federal court, but whatever. Exclude reporters from the trial. They found that the First Amendment interests of journalists to report on a high-profile matter of great public concern outweighed the minuscule risk that if called as impeachment witnesses, their presence covering the case's journalists could shade their testimony. The court also questioned the defense's claim that testimony from any of the journalists would be admissible or necessary. Wait, am I missing a page? Oh wait, I went too far. I went a bridge too far. There was another part. Okay, here, the ostensible purpose for the Commonwealth's inclusion of Mr. Kearney on their witness list is to keep him on ice as a possible rebuttal witness regarding Miss Reed's purported consciousness of guilt, in scare quotes, based upon her alleged communications with Mr. Kearney. Notably, the Commonwealth already has represented to the court that they do not intend to introduce any such evidence in their case in chief, and that they only intend to do so on the rebuttal case if the defense opens the door. During cross-examination of witnesses the Commonwealth alleges were intimidated by Mr. Kearney and Miss Reed. At best, the purported evidence of Miss Reed's consciousness of guilt and Mr. Kearney's testimony in support of such a claim is weak, speculative, and to the extent that it is even remotely admissible, its probative value almost certainly will be outweighed by its prejudicial impact. All right, guys, first in the chat to cite, what rule is that? What rule? Prejudice. Oh my God. Prejudicial versus probative. What rule are we talking about there? First in the chat wins a million scroll points. Name that. We're playing the name that rule game. Love that. It's our favorite new game here on the channel. Thus, without regard to the merits of the Commonwealth speculation about good guess, but not exactly. 401 is relevancy. Try again. I think you'll get it on try number 2, Wiz. Let's go with third try as a charm. Oh, fuck. No. Fourth try. So we have 401, 42, 404. Fourth try as a charm. Go down. There's one that you're missing in the sandwich of rules. Propagand's lurking while at work. Love it. There you go. Ding, ding, ding. Good job, Twiz. You get a, what did I say? 1 billion scroll points to go to Twiz. And 402, you never hear about. Okay. And here's why. Because 402, so 401 being relevance, right? 402 is the general admissibility of relevant evidence. And all it's basically saying is relevant evidence is admissible unless the U.S. Constitution or any other statutes provide otherwise. So you don't really ever hear that cited. You really hear 401, 403, 404. And there's 404A and B, as we've talked about. And I'm sure we will continue on with our name that rule game at another point. So shout out to Twiz for getting rule 403. Excellent. You thought what was relevant? So yeah, prejudicial versus probative, that's your 403. So that's because that's excluding relevant evidence for, and then there's the whole long list of reasons. But included in that is the prejudicial versus probative balancing test. So if it is, so for example, if it's relevant, but it's found to be more prejudicial than probative, right? Then you can exclude the relevant evidence for that purpose. All right, that's without regard to the merits of the Commonwealth speculation about Mr. Kearney's knowledge or ability to provide relevant evidence of Ms. Reed's purported consciousness of guilt. The likelihood of the admissibility of the evidence and or Commonwealth's need for Mr. Kearney's testimony at trial is virtually non-existent and is substantially outweighed, balancing test, right, by Mr. Kearney's First Amendment right to report on the case and his right to earn a living. Yeah, you still got the points. By the way. Assuming arguendo that evidence of Ms. Reed's consciousness of guilt based upon her interactions with Mr. Kearney is admissible, it is hard to fathom why the Commonwealth would deliberately draw attention to Mr. Kearney's actions and his motivation for them by calling him as a witness without having any opportunity to speak to him in advance of his testimony. It strains credulity that experienced prosecutors would willingly afford Mr. Kearney the opportunity on direct examination, no less, to explain and then place in context the substance of his purported communications with Ms. Reed, where such evidence clearly would be harmful to the Commonwealth's case and almost certainly support the defense's position. Put simply, the likelihood that the Commonwealth will actually call Mr. Kearney as a witness appears virtually non-existent, just like that waterfall. It is clear that Mr. Kearney's First Amendment rights as a journalist to continue his reporting on a matter of great public concern and to earn a living substantially outweigh the Commonwealth's dubious and transparent speculative assertion that he be needed as a rebuttal witness. Mr. Kearney respectfully brings this matter to the court's attention before jury selection begins on Tuesday, April 1st. In these circumstances, enforcing a general sequestration order to exclude Mr. Kearney, a credentialed journalist, from attending the trial and reporting on this case would violate the First Amendment. There is no question that he has a First Amendment right to attend the case. Okay. To the extent the Commonwealth has, in fact, sought to exclude Mr. Kearney because he's a well-known, vocal, and prominent, I was wondering if they were going to get to this, critic of their case against Ms. Reed, the First Amendment does not permit or tolerate discrimination between members of the press in granting access to trials and other governmental proceedings, including where, as here, Mr. Kearney's exclusion appears to be based on disdain for the content of his reporting rather than his actual need as a witness. See footnote 1. During the first trial, Detective Tully, an essential witness against Ms. Reed and Mr. Kearney, acting as a messenger, in scare quotes for prosecution witness Gretchen Voss, redacted. Ms. Voss did, in fact, attend the trial despite being on the Commonwealth's witness list. That's important. That's good. Good fact for him, for Turtleboy. Okay, and then they're citing the case law here. Exceptions to sequestration orders are commonly granted. There is an abundant precedent for exclusion from a sequestration order with respect to certain categories of witnesses, such as government case agents in criminal cases and expert witnesses in both civil and criminal cases. Given the likelihood that Mr. Kearney will be called the unlikelihood, rather. Twiz be sticking up for the cult leaders, guys, for anyone who's missed it. What do y'all think about that? Given the unlikelihood that Mr. Kearney will be called to testify, and in view of the exceedingly narrow scope of any relevant testimony he might offer, the public interest in his being able to cover this proceeding far outweighs any conceivable interest in excluding him from the trial of this case. Meg, I'm just glad you included the word allegedly there. Like, I'm not allegedly judging. I'm judging people who think I'm allegedly judging. That's hilarious. Indeed, the Commonwealth sought and obtained exemptions for DA Morrissey and a victim advocate in the case. Every time I hear victim advocate now, all I can think about is freaking Wendy and the victim advocate and the skirt and all that. The victim advocate in this case at the final pretrial conference, 2 witnesses who clearly favor the prosecution in this matter. Finally, based upon their placement of Mr. Kearney on the witness list and recent filings and proceedings held before this court and Judge Sisitsky, is that the judge that, I guess that's got to be the judge that was there at the hearing. It is obvious that the Commonwealth, A, believes that Mr. Kearney's testimony will incriminate both himself and Miss Reed, and B, knows that if Mr. Kearney is called as a witness, he will be unable to report on this case. Footnote 2. The irony of the Commonwealth's conduct is not lost upon us. In essence, I love the spicy filings, guys. In essence, the Commonwealth has placed Mr. Kearney on the witness list for the purpose of silencing his criticism of them, with full knowledge it will cause him economic and or emotional harm, which is a form of harassment. Oh, wow. Oh, fuck. Which is a form of harassment akin to the witness intimidation charges they've repeatedly charged him with. Wow. That is very interesting. That is interesting. He's got a point, because in Massachusetts, the rules about the witnesses are insane. Runkle has covered those. It was a while ago, like probably months ago, but I had no idea they were that insane. It's not like that in any other state in the US. And it's basically like simply like breathing air near a witness could be enough. It's really crazy. So this is really interesting. It's a good point. It's a fair point, right? That because he's on the witness list, causing him emotional harm, should throw them or at least get them stuck with some charges like what they've got going on with him. That is very interesting. Okay, as the court is aware, Mr. Kearney presently is under indictment for several counts of alleged witness intimidation related to his interactions with some of the witnesses against Miss Reed. Why don't you come on so we can debate it, Twiz? Has the court, wait, hold on, I already read the part. Okay, in March 2024, a grand jury declined to, I guess they forgot the word indict Mr. Kearney and Miss Reed for conspiring to commit witness intimidation. But on March 20th, 2025, Special 88 Cosgrove represented that this matter was still under investigation and could result in the Commonwealth impaling a second grand jury. Jesus. Putting aside the issue of whether the Commonwealth may offer Miss Reed's alleged uncharged, quote, bad acts, end quote, which are presently under investigation as evidence of her consciousness of guilt, in scare quotes, during this trial, as a matter to be addressed by Miss Reed's legal team if appropriate, it is clear that if Mr. Kearney were examined under oath as a prosecution witness, the Commonwealth would seek testimony from him, which they would deem incriminating to Miss Reed and himself, as related to his existing indictments and the alleged investigation cited by Mr. Cosgrove. There can be little doubt that the Commonwealth would then seek to use Mr. Kearney's Reed trial testimony against him in proceedings against him. Interesting. I don't even know what you're talking about, Twiz. You said you just watched me. Are you talking about the... Hey, oh, boy. I mean, I figured he's talking to me, Meg, not you. but maybe he's talking to everybody. You know, the whole world he thinks the whole world is judging the cult leader. So, okay. In these circumstances, as attorneys for Mr. Kearney, we have no choice but to inform the court that if Mr. Kearney were to be called as a witness against Miss Reed, due to the proposed subject matter of his testimony and the circumstances described above, on advice of counsel, Mr. Kearney will assert his Fifth Amendment privilege and refuse to answer any questions. This fact, without more, should exempt Mr. Kearney from being subject to the court's order for sequestration of witnesses. For the foregoing reasons, the court should allow him to be exempted. Bada bing, bada boom, bibbity bobbity boo. Oh, okay. Thank you, Meg. I hope if there's ever like an award that goes to a YouTube channel with like the most like opinionated mod of all time, I think we might win. Okay, next. Judge Bev with another lovely decision, decision in order on defendant's motion to exclude testimony of Commonwealth's witness, Judge Welcher, right? Judson Welcher. Okay. After review of the party submissions and consideration of the 5 Daubert-Lanigan factors, the court concludes that there is no reason to preclude the testimony of Dr. Welcher outright. Dr. Welcher has the requisite education, training, experience, and familiarity with the subject matter to qualify him as an expert. That's not what they were arguing. It had to do with the whole causation of the injury shit, if I recall. And his report demonstrates that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury consideration. Oh, wait, he was the dude also. Yeah, it was twofold. It was that he was going to be offering an opinion on a cause and manner of death, but also, which Judge Bev's own made up rule said you can't do, but also that he was relying on like the witnesses and shit. Sister Nagel, Brother Nagel, and the like. Most opinionated and most likely to sleep through a stream mod award goes to Twizzles. Well earned and well deserved. Congrats, Twiz. Absolutely. I love how she included even the emoji for the medal. Like, that's amazing. The defense raises several challenges to specific slides, and we covered on the last Karen Reed live stream the one where they talk about his PowerPoint that he never fixed, which he was supposed to. So specific slides provided by the Commonwealth in support of Dr. Welcher's anticipated testimony. Dr. Welcher's expert report accompanying the slides, however, indicates the information and methodology relied upon in forming his opinion. To the extent that the Commonwealth seeks to elicit evidence that the defendant believes is beyond the witness's field of expertise, it is not supported by the methodology that is commonly, again, typo, accepted in the relevant scientific or technical community, or relies improperly on witness statements, sister, brother, Nagel, and the like. Defense counsel can object to the line of questioning at trial. Whether it will be necessary to take evidence outside the jury's presence prior to the admission of specific testimony by this witness need not be determined at this stage of litigation. So in other words, it's denied, but it's kind of not fully denied because she's just saying it's not ripe, essentially, right? We can deal with it. We can procrastinate is what she's kind of saying. I mean, it's denied, but it's like it could change. Number 1 map. Oh, Twiz. Twiz and his maps. Okay, next we have defendant's response to Commonwealth's renewed motion in limine to exclude Garret Wing. Now comes the defendant in the above caption matter. The entirety of the Commonwealth's renewed motion appears, and we covered the renewed motion last time on the previous Karen Reed live stream. Actually, sorry, there's a footnote. Let's go to the footnote first. Defendant does not waive any and reverses any argument put forth. Reserves. Oh my God. Does not waive and reserves any argument. Okay, fine. That's fine. That's not exciting. The entirety of the Commonwealth's renewed motion appears to be based upon the inaccurate premise that the defense intends to call Garret Wing as a sur-rebuttal expert. Right. That's what they said. That is what they said. That's what she said. That's what they said. The Commonwealth witness, Dr. Crosby. That is what they said. In actuality, the defendant intends to call Lieutenant Wing as an expert witness in her case in chief, and not as, so the Commonwealth's entire thing was completely unfounded then. So they're idiots, basically. They're going to call it in their case in chief, not sur-rebuttal. So, oh, Commonwealth, get it together, Breenan. And not as a rebuttal witness to Dr. Crosby's testimony. On this basis alone, the Commonwealth motion should be denied. Yeah. And also they should not be so confused and terrible. As the defense had stated previously, on June 18th, 2024, this court determined that only a medical doctor, she did this, could opine on the I just love it because Judge Bev is like, it has to go back on her own thing because if she's that biased, it's just, could opine on the medical cause of injury to a human. Until March 6, 2025, the defense therefore operated under the impression that only medical doctors are able to testify. In other words, they followed her rule, right? Are able to testify as to the medical causation of an injury to humans, including injuries caused by dog bites and or claw marks. Meg's encouraging Twiz to get into cell phone forensics. Yeah, for real. The court's March 6th order caused the defense to revisit the topic of the wounds to the right arm of the decedent, including potential witnesses, expert in, I guess it's supposed to say expert witnesses. They got the words reversed. Expert witnesses in dog-inflicted wounds on humans who are not medical doctors. At no point did the defense ever express that Lieutenant Wing is intended purely as a rebuttal witness for Dr. Crosby, rather that the court's determination on Dr. Crosby, including the defense's motion for reconsideration of the March 6th order, would inform defense strategy regarding Lieutenant Wing. Additionally, until the the new Twiz Ray, I love it. It's great. That's it. We want Twiz Ray for sure. Additionally, until the March 6th order, several questions remained about how the defense would proceed relative to the Commonwealth's treatment of Dr. Crosby. At oral argument on March 4th, the Commonwealth verbally stated that it did not intend to call Dr. Crosby in their case in chief and intended only to call him as a rebuttal witness. Again, so it's like literally, why? Oh my God. So the Commonwealth said the defense was going to call this Lieutenant Wing as a sir rebuttal witness when instead it's really the case in chief. And also the Commonwealth said that they did not intend to call Dr. Crosby during their case in chief and instead call him as rebuttal, but instead they're calling him in their case in chief. This is just a mess. The court asked, just to be clear, yeah, I remember this. The Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief. Right. And the Commonwealth responded, absolutely not. That's exactly what happened. That's right. Interesting. However, the court's March 6th order contained no such limitation on the scope of Dr. Crosby's testimony. I see. He's saying, they're pointing out to Judge Bev, hey, you're the pot calling the kettle black or whatever. Like, interesting. Right. Because the scope of his testimony needs to be different if he's in the case in chief. Wow. All right. Contain no such limitation on the scope of Dr. Crosby's testimony for the Commonwealth to call him only as a rebuttal witness. Due to the lack of a memorialization of the Commonwealth stipulation, the defense reasonably assumed that the Commonwealth could call Dr. Crosby in its case in chief should it choose to. For the first ever time in writing, and after receiving the report of Lieutenant Wing in its renewed motion, the Commonwealth states that it intends to offer Dr. Crosby only if necessary to rebut the testimony of Dr. Marie Russell. The defendant intends to call Lieutenant Wing as an expert witness in her case in chief. Lieutenant Wing's decades of knowledge, skill, training, expertise, and experience, together with his documented methodology, qualify him on the expert of dog-inflicted wounds to humans. To cure any perceived complaints by the Commonwealth with Lieutenant Wing's original report, the defendant will provide an amended report of Lieutenant Wing, which will remove all references to Dr. Crosby. The defense expects to provide this amended report to the Commonwealth within the next 5 calendar days. Hello, James. Welcome. Take you under his wing. As the defendant intends to call Lieutenant Wing as an expert witness in her case in chief, the discussion of law on page 2 of the Commonwealth's renewed motion is inapplicable. This notwithstanding, and in reference to the Commonwealth's incorrect assumption that the defendant intends to call Lieutenant Wing as a rebuttal witness to the testimony of Dr. Crosby, the Commonwealth states in its renewed motion that there is no sub-rebuttal in Massachusetts courts, which we know. Therefore, even if, and honestly, it's very, very rare anywhere, to be honest. Therefore, even if the defendant did intend to call Lieutenant Wing as a sub-rebuttal expert, there is no Massachusetts law the defense could locate that would prohibit her from doing so. And indeed, there's contrary law in her favor on the issue. On what tour? Conclusion: for the reasons set forth, the court should deny the Commonwealth's renewed motion eliminate to exclude the testimony of Garret Wing, etc., etc. Finally, actually, I should read this last part. Finally, and in the alternative only, surrebuttal witnesses are allowed to be presented in Massachusetts. For these reasons, the court should deny the Commonwealth's motion. Okay, excelente. So now we're going to pull up the Canton. I think that's the last one. Yep, that's the last one of the recent filings that have come out for Karen Reed. Sure, there will be more, but now we're going to go to this. All righty. So I'm just scanning this here. So of note, right? It says our final report has identified opportunities for improvement in several areas and offers key recommendations as set forth in the attached report. Oh boy. So this is 206 pages. I think we can jump to the final report. I mean, I think honestly, probably all of this is worth reading. But let's see. That says page 184. Oh, I wonder. So it says that they conducted interviews with all Canton Police Department employees. Interesting. They were all candid, cooperative, and forthright. Well, fuck me. Not included in the audit. Analysis of evidence collected in ongoing or prior criminal cases. Fucking hell. What was included in the audit? Assessment assessment of policy compliance with standards of law enforcement and accreditation organizations, assessment of the application of policy in recent investigations. So let's just say this. If Karen Reed was not having a second trial, let's just say she'd been acquitted or convicted or something in the first trial, and then actually I guess she would have had to been acquitted. Because if she'd been convicted and she was in the appellate process, they might still have counted that. Anyway, but what I was going to say is, like, if we weren't where we are now, potentially they could have analyzed the evidence in that case. That's a real shame that that's not here. Okay, and then assessment of the written policy and protocols as applied in recent investigations. So, okay, so let me just make a distinction. So that would include potentially Karen Reed in terms of the written policy and protocols, but just not the collection of evidence, which, well, analysis of the evidence collected, like, I feel like that's what really we would want. So for cases that are not ongoing criminal cases, oh wait, hold on, let me back up. This is ongoing or prior. Never mind. So in other words, never mind. I retract that statement. They're not going to analyze the evidence for any cases. Never mind. I retract that statement. Okay. But the procedures of collecting evidence would still be fair game, it looks like. And then the presentation of findings and recommendations. Methodology. So let's go to that page it had where it would give their major. And we can always, okay, maybe it was 184. The areas of improvement. Let me see. Can I just type it in? That'd be convenient. Aha. Okay. Recommendations. All right. In relation to the investigative reports authored, let me zoom in. Oh my God. Authored by Canton PD members and the interview with ADA Connors, the audit team noted potential deficiencies in the reporting process. These included inconsistencies and gaps in information. The audit team conferred with ADA Connors to ensure some of the recommendations being made by the audit team would align with the objectives of the district attorney's office. ADA Connors agreed with the below recommendations. Officer identification. The Canton PD reports should prominently feature the names of all officers involved in the incidents, as well as the names of judges, prosecutors, and defense attorneys related to the case. Simplify reporting. The Canton PD should consolidate multiple brief reports into a single, detailed, and concise comprehensive report. This approach would help prevent contradictory statements and inaccuracies. use of audio recording devices. So that was one thing, again, with Karen Reed, that was a problem. They did not record shit. And there was like missing body cam from shit as well, right? Well, I mean, there were other, just, there's plenty of issues, but just in terms of related to this particular note here. Canton PD officers and detectives should utilize audio recording devices during witness and suspect interviews with consent whenever possible. This would ensure accurate documentation of interactions. Department issued mobile phones. Oh boy. Each member of Canton PD should be equipped with a department-issued mobile phone for official use. This would facilitate effective communication of work-related information and allow for the capture of photographs at crime. Okay, I was thinking, is it going to say something about you can't dispose of it at a military base? I mean, I know that he wasn't Canton PD, but still, there's so much funny business going on with the phones, but that's kind of, boring. Additionally, ADA Connors raised safety concerns about ATF operations. Oh, keep reading, Chelsea. He noted that some operations orchestrated by agents seemed to target arrests in the town of Canton. Oh boy, raising concerns about the safety of such initiatives. ADA Connors supported the implementation of the body-worn camera program, advocating for its utilization by the Canton PD. Drawing from his own positive encounters, he highlighted the benefits of the body-worn camera program, particularly in enhancing officer safety. Concerning the involvement of informants in state cases, ADA Connors stated that in the state of Massachusetts, informants lacked legal protections. Their role was confined to providing initial tips, just the tip, and they were managed accordingly. Expressing reservations, ADA Connors discouraged the reliance on informants in proactive undercover or police operations to mitigate potential risks of exposure. Okay. So shouldn't their final recommendations and whatnot be like the very last thing? I'm confused. Like what's on the last, let's see. Oh, this is interesting. Efforts to repair the relationship between the Canton PD and the town of Canton community must be an ongoing process. Wow. So they're acknowledging the dissonance there. The audit team noted instances where some policies were not fully followed and noted recommended changes within. Proven records demonstrate compliance with even the smallest policies. Let me read that again. Proven records demonstrate compliance with even the smallest policies, produce a tangible metric of trustworthiness. Yeah, follow your policies. Efforts to initiate compliance metrics demonstrate transparency within the community of the town of Canton. Huh. Interesting. When feasible, opportunities should be explored for educating the community on law enforcement practices and procedures. Engaging with the community in this way not only invites understanding of the challenges facing police, but also facilitates an appreciation for law enforcement officers as true professionals in their field. Well, good luck with this here. I mean, maybe elsewhere, but I mean, the problem is who they've got, right? Like the police officers. I mean, there's just a lot of issues. So let me go. Let's just see here. Let's go. Let's just take another little look-see and see if there's any other little interesting things here. Executive summary. So over 10 years for this audit. Over 40 police officers they interviewed. Okay, we went over that part. Are you browsing online, Meg? Did you end up buying anything earlier when you were browsing too? Interesting. As the audit team worked through the scope of work, numerous findings highlighted discrepancies between written policy and implementation. The audit team has put forth recommendations in the body of this report in an effort to assist the town of Canton in enhancing policy compliance and operational efficiency. Okay, interesting. So we can find, okay, so it says, while the audit covered 20 sections, the areas of crime scene protocols, professional standards and accountability, organizational structure and governance, management, operations and culture, hiring, training and equipment, and evidence are the main areas in which the audit team identified immediate action and development items. Oh, good. Are they going to outline it here? Okay. Evidence and crime scene protocols. The audit team reviewed a series of crime scene incident reports spanning over a decade. While some investigations were found to be in line with established guidelines, there were cases of policy breaches mainly related to the use of digital photography for documenting crime scenes as required by the Canton PD's evidence collection and preservation policy. Additional shortcomings were identified in the areas of crime scene preservation and detailed incident documentation. Our evaluation included a detailed analysis of the Canton PD policy and procedure with a specific focus on evidence collection number 6.01. This policy outlines the responsibilities of first responders in evidence collection, crime scene preservation, and documentation. Initial recommendations were for the sergeant or shift manager to take charge of the crime scenes and for additional training for Canton PD personnel to handle or supervise evidence collection. Oh, fuck. During the examination, the audit team assessed the response and crime scene procedures carried out by Canton PD officers involving the tragic death of John O'Keefe. These actions were compared against existing policies, regulations, and requirements to determine compliance. The review of this major incident encompassed crime scene investigations. Okay, here we go. Policy violations were identified in detail below. Interesting. All right, observations and findings. First responders should have photographed Boston police officer John O'Keefe at the location of where he was found before fire and rescue moved him to the rescue. Yeah, common sense. All interviews of critical witnesses, including Jen McCabe and Carrie Roberts, should have been conducted at Canton PD on January 29th after he was transported to the hospital. Consensual recorded witness interviews should have been conducted. So they should have recorded their interviews, right? As I mentioned earlier. The MSP, along with the Canton PD, should have maintained a police presence at 34 Fairview Road pending the secondary search. Yeah, they should have stayed there and not left. Yeah. All video footage. Oh my God, is this the Lallyport? Oh my God. All video footage files maintained on Canton PD's computer systems of Karen Reed's Lexus SUV while it was housed at Canton PD should have been requested and turned over early in the Karen Reed case to lead investigators. Yep. They should have turned it over. I mean, but are they not going to get in trouble? Like, they need to be getting in trouble. Okay, professional standards, internal affairs. There's a lack of organization and consistency, particularly during the tenure of 4 Canton police chiefs, and they include in that Helena Rafferty. Observations and findings. The Canton PD's internal affairs process is inconsistent regarding investigation and documentation methods. No surprise there. The audit team found no instances where complaints were intentionally ignored or officer misconduct was arbitrarily excused, but the consistency in how cases were handled varied greatly. Several misconduct complaints were handled directly by the chief of police. The audit team recommends hiring outside firms for internal affairs investigations where conflict and potential conflicts exist, or cases where multiple police officers are involved. Yeah, should go without saying. The internal structure of governance. The Canton PD had 3 internal affairs investigations in the past 3 years as a result of police officer dispatch failures. No civilian dispatchers are employed by Canton PD. They only have 1 part-time civilian employee. Wow. The following 2 quotes given by 2 separate Canton PD officers during their interviews highlight the chasm that exists between the Canton PD and town officials. So here's the quote. "No one in this town will care about us until one of us gets murdered. Even then, half the town will probably celebrate that." And then another quote, "Elected officials don't care about us. Now the easiest way to gain popularity or get elected is to publicly trash us. They have no political platform, just trash the police. That's it. It doesn't even have to be true. Just do it." Well, can't say it's not particularly warranted in this case. The Canton PD has above average morale as it relates to camaraderie and faith in the department. Yeah, but sometimes that can be not so much a good thing because it's like a boys' club and, they maybe go a bridge too far with protecting their own, right? Maybe. Interviews conducted by the audit team revealed that officers do not feel they have the support of the Canton town officials. Canton PD officers' morale as it relates to its relationship with the town is low. So they have so in other words, the police officers have a great thing going with each other, but that's about it. With the rest of the town, no. The audit team has been informed that town meetings in the town of Canton devolve and become contentious and unproductive. Yeah, I hope they watched some of those, the audit team, I mean. Interesting. The situation here about, okay, I'll just read this paragraph. The audit team has pinpointed locations in the town of Canton where the Canton PD portable radios are not functional. Oh my God. Given that the officers are not equipped with department-issued cell phones, which they also did recommend, as we read earlier, that they recommend that they have those, the scenario where a Canton PD officer may be dispatched from their marked patrol car to address an emergency situation on Washington Street without any means of communication is realistic and concerning. This situation could leave the town vulnerable to legal action. Observations and findings. The Canton PD detectives need advanced training in crime scene investigations. Yeah, the Canton PD needs increased training budget approved by the town. Civil service standards place a limitation on who can be hired by the town of Canton. Portable radios and their inability to provide complete coverage is problematic. Canton PD officers are not issued department cell phones. So here's some recommendations. Recommendation: all sergeant and patrol vehicles should have full crime scene kits, including evidence collection bags, sealing equipment, and digital cameras. Yeah. And then recommendation number 3, rewrite Canton Police Department policy and procedure related to utilization and authorization of personal phones to photograph or video crime scenes. Recommendation 4, relinquish 911 and dispatch responsibilities to the Holbrook Dispatch Center or hire full-time dispatchers. Number 5, increase training opportunities. Number 6, Chief of Investigations Division should review all death investigation police reports to ensure completeness, accuracy, and exhaustion of all investigative avenues. Look at this. Note, a Canton PD detective wrote that Sandra Birchmore died of a suicide in the initial report. It was later determined that she'd been killed by strangulation. Yeah, that's a good example. Number 7, provide prompt, proportional, and consistent discipline across the department. Discipline process was not always applied consistently. Background. So those are the areas that they mentioned for the needs improvement or whatnot. Oh, look, there's the structure. Interesting. So that, I think that is the bulk of the what their findings were. Now, of course, there's going to be more detail in here. This might be worth going through more at some other time. Let me know if you guys want to go through more of this specifically. It does have the table of contents. Where is it? I mean, I think having said that, I think that it would be worth taking a look at page 20, evidence, search and seizure, electronic devices, chain of custody. Let's just see here what they got. Oh, you know what it is? It's page 20 of the document, I guess. But it's off by 7. Okay. So it would be page 26 or 27, I guess. Let's see. Okay. Temporary evidence room. Stop and shop bags in the Lallyport. Anyone? I mean, it prohibits, look at this, it prohibits unauthorized storage of evidence outside designated areas. I mean, Jesus. Please tell me they saw the red Solo cups in the Stop and Shop bag in the Lallyport. I mean, this is shocking, though. Overall, the Canton Police Department demonstrates a commitment to best practices in law enforcement evidence management, ensuring both legal compliance and protection. How did they have that finding? Okay, recommendations. Again, some of this is, there's an overlap here, the digital cameras, unannounced audits. Right. Again, like they should all have a crime scene preservation kit. Eyewitness interesting. That they did fine on. So I guess what it's going to look like then, in like for each category, it's going to have the recommendations, and so they can have none. Testifying. Interesting. So here they do say the audit team recommends training on testimony clarity, handling disagreements professionally, identifying assumed truths, exposure to high profile cases. Canton PD should consider mock trials or role-playing exercises. Role-playing? I'm just kidding. In conjunction with the DA's office. Continuous skill development. Mental health. Let's see what they have. Yeah, their main thing here is being for them to get along with the town, right? So that's their only thing there. So yeah, it might be worth going through and just looking at the recommendations for each category. But I think we'll do that on another live stream. And that way we can go from beginning to end in order. Now that I have a better feel for like the layout of this thing, but at least we went through the most substantive overall findings as to the audit and what they discovered. I am still surprised that it said anything was adequate in terms of the evidence collection, because again, it's like, what are you doing? But it is what it is. So so I do believe that'll be it for this one. Let me just double check and make sure there wasn't any new surprising Karen Reed documents that came out in the past like hour or so, just in case, because I should have all the latest ones already. Let's just see. Here's just an update for jury selection, though. Out of more than 170 people who have been screened so far, 150 admitted to knowing and or talking about the case with others. 7 jurors have been seated. That was from 19 hours ago. So it's possible the trial could start next week. No, but there's no other new filings here. Let me just see if there's any other updates, if they've seated any more jurors. Okay, so they've got from 40 minutes ago, so this is recent. It says nearly half of the seats have been filled. It's still 7. So they've not seated any more jurors as of right now since yesterday. So yesterday they had 7 jurors. Right now they still have 7 jurors, and they're looking for 16. And the 7 they've got so far is 4 men and 3 women. So far today, of the 40 prospective jurors brought in today, 37 have heard of the case and 21 have formed an opinion. Also, 21 also said that serving would be a hardship. I think they're at lunch right now. So, okay, so there's a timestamp. Oh, interesting. So there's a timestamp here from like 11:30. At sidebar questioning, Karen Reed is sitting on some benches. It's unclear how much of the conversations she can hear from that position. So they didn't give her the headphones. Now the judge asks that the man at the bench step away. They huddle. Robert Alessi speaking to Judge Bev. Breenan's talking. They go back to the bench. The judge's talking to him. He smiles and shrugs. This is the potential juror. And then he leaves without any announcement. So interesting. So that's where they're at now. So yeah, I'm sure they're at lunch, and that's why the recent update is from 40 minutes ago. So there you go. So 7 down, 9 to go. 7 down, 9 to go. I did see that. Yes, I just surely did. Yep. That they can get up to $300. Yep. Did I miss that part, Candace, about the 5SI? Right. Yes. We covered that because I've been relying a lot on his reporting. I love Nadine, but yeah, we've been relying a lot on his reporting. And he had that. I had that thing on the screen of actually, I think I still have an image of it saved where he had this turn, the court days and all that info on there. But yeah, I love Nadine. So I'm looking here. Is that Candace? Was that a joke? Oh, you're on their website. Interesting. That's interesting. Thanks for letting us know. That's interesting. So then this is legit. All the 5SI core values are Christ-centered. That's the people who did this audit. Interesting. Wow. Yeah, Five Stones Intelligence. Yeah, interesting. I'm you mean covering it? I mean, I listened to it live when it was happening. And we did go back and listen to the specific part. Actually, we listened to, I think, all the testimony of who was it? Detective, oh my God, what was his name? The agent, forget blanking on his name. The agent, oh my God. The agent who read all those text messages and had to read them on the stand. We went back and listened to that testimony because I wanted to make sure everybody heard the part about the storm, but we listened to that entire thing where he was reading all their entire text and email history because it was amazing. And are you wondering if I'm covering the first trial there or? But yeah, I was listening to that at the time. I'm trying to think of when we listened to that testimony about the Grab Me by the Storm. It might have been the first episode in the Lori playlist. That might have been when it was. To get some people familiar with, in case people weren't familiar with her other trial, right? To get them familiar. I bet that's probably where it was. But yeah. And I really loved that agent. I can't remember his name though. Let me see if I can find that. He was awesome. Doug Hart. That's his name. Doug Hart. And Nate Eaton did interview Doug Hart. It's not long. But I'm sure on our next Lori Vallow stream, we will watch that because again, I love that agent. And I knew that Nate was planning on interviewing him and I've been looking forward to that. So I'm sure we will watch that on our next Lori Vallow stream. So, her opening statement start on Monday. So Oh, that's awesome. Yeah. So, I mean, I don't know if anybody wants me to cover the first trial. I mean, again, because audio only, it's not like the greatest thing to cover. But the thing that was really important for me was that everybody heard the text message history of Lori, because it's like there's the storm, there's the Harry Potter bit, there's the Lori's Beachbody diet. There's so much good stuff in those text messages. And then there's also, of course, really important information too as it pertains to the case. So that's why we did go back and listen to that testimony. And yeah. So is the yes with a question mark like you do want me though to cover the trial, the audio only trial, or bias-free policing? Interesting. Yeah, I mean, if there's like certain witnesses that were, I mean, it's been a long time. Like I haven't gone back and re-listened to the whole trial. Like I listened to it again as it was happening. Like I said, I've gone back to listen to that testimony from Doug Hart, but I haven't gone back to listen to, I don't think, any of the other witness testimony. So I don't recall. Like I think Colby, like just trying to think off the top of my head, like Colby would be noteworthy. What's her face? Zulema, and then there was the other friend. I think all of Lori's friends, I would say, might be worth going back and listening to. I don't know how many of them. The thing is I haven't seen the state's witness list for Arizona. Does anybody know if any of those same people are going to be called for this trial? Like the people who were in the quote unquote 144,000, but it was really like 5 people. Do y'all know if any of them are being called for this trial? Because if not, it might be worth going back and listening to some of that testimony. But if they're going to be called again, then I would imagine we'll hear some of the same testimony. If not, I mean, unless they want to get impeached, right? It's all good. I mean, I don't, it's hard to get access to that stuff, but it's possible that Nate Eaton covered it at some point, the witness list. I'll see what I can find though, as per that, as to the witness list. I mean, we know the defense witness list because that came up in the hearings, right? But as far as the state's witness list, that one I don't know as much about. But anyway, that'll be it for this one, guys. We will be back later tonight after I finish teaching for Brian Koberger, barring something crazy maybe happening with Karen Reed today. If there's something else, more pressing with some of these filings or what have you. But other than that, we'll be back for Brian Koberger. And yeah, but y'all are awesome. Freaking love you guys, Scroll Crew. We'll just enjoy looking one more time at this Canton Police Department. Actually, let's just do the building. There we go. I'm sure you guys have noticed in the thumbnails for this, for every time I do a thumbnail for Karen Reed, I've got the Canton Police Department sign in the front yard of 34 Fairview, which I saw somewhere that it's no longer findable on Google Earth. I don't know if that's true or not, but I saw that somewhere. I haven't checked, but apparently they've disappeared it. But anywho, but Twiz is saying good night. What a Twiz. But yeah, we will be back later for more. But love y'all. Enjoy looking at this building while I find my little outro here. And I'll see y'all next time.